Please be seated. Good morning. We are here for oral argument in cause number 1CA CV180444, Korak versus Para. These proceedings are being audio and video recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel, you are advised that you're responsible for watching the clock to reserve a portion of that time for rebuttal if you so desire. We've read the briefs and discussed this case this morning in conference, and you may proceed.
Since you've read the briefs and you have discussed it, I suspect that because of the limitation of time that it's not intelligent for us to spend a lot of time on things that you already know. The key to the whole thing is whether or not the doctrine of res ipsa loquitur gets us to a jury.
Can I ask you a preliminary question?
I'm sorry?
Can I ask you a preliminary question?
Yes.
Why do you rely exclusively on the doctrine of res ipsa loquitur?
I'm sorry.
Why do you rely exclusively on the doctrine of res ipsa?
Because, and I'm not sure that your statement is correct, could we get to a jury without consideration of that doctrine? We should be able to. The reason why we're relying on res ipsa is because of the fact that our expert, whose first language was not English, made some statements during his deposition that could be considered to be some kind of waffling. The question is, what caused the damage to this lady's organs? First of all, to the liver. Secondly, to an artery that feeds her spleen, which she later lost because the artery burst. Res ipsa simply is a doctrine, as you know, that allows you to get to a jury without proof of actual basis for negligence if, in fact, four elements are present. Number one, that the event does not normally occur unless somebody makes a mistake. Number two, that whatever happened, it was within the exclusive control of a defendant. Number three, that the plaintiff wasn't involved in it. And all of those elements, in fact, exist here. We don't know for sure what Dr. Para did that caused injury to the splenic artery. Initially, our expert witness opined that it had to be a trocar. What happens, of course, is that they make 4 or 5 incisions in the abdomen, and they stick a funnel-like instrument through those incisions. The first one is blind. It's done without the ability to regulate exactly where this gadget's going. And for some reason, Dr. Para put that first one in right where this lady's spleen is. She had had previous surgeries having to do with weight issues, and perhaps what he decided, and we did not depose him, was that it's best to get away from the normal umbilical insertion in the belly button area. Somehow, something caused damage to that artery at the time that the surgery was done. And when the surgery was done, normally, according to our expert, you need to make sure that you don't cut into the liver. They use instruments through those little trocars to remove the diseased organ, the gallbladder. I suspect they cut it up in pieces and pull pieces of it out. But somehow, even though Dr. Sangoday, our expert, said that He had done, I think, 1,700 of these operations, and he was involved in groups where there were many others done. He had never heard of anybody doing what happened in this case in either of the elements of damage to the body.
So is his opinion then that doing the operation in this way, is his opinion that doing the operation in this way violated the standard of care, or is his opinion simply that there's no other explanation for the harm that befell your client?
Doing the operation the way it was done, as what they call a laparoscopic cholecystectomy, is the way it's normally done. If they can do it that way, it's their favorite way because they don't have to cut into the body except for those little incisions and the insertions.
Well, I may now be understanding why res ipsa is so important to your theory, but do you have anywhere an opinion that says that anything that the defendants did here fell below the standard of care?
Everywhere. In the first place, these things don't happen unless somebody fell below the standard of care. That is made certain by Dr. Sangove, our expert.
Although typically in these affidavits you have somebody say, here is the standard of care and here's why what was done fell below the standard of care.
Well, for some reason, the trial court determined there was a violation of the standard of care. That was never explained. I don't know exactly in the explanation that he gives in his final ruling how that's covered, but there's a violation of the standard of care somehow. It was causation that the trial court got hung up on, stating that even though he finally came around to the idea that this was a res ipsa case, that because of the fact that our expert said that two things. One, as to the liver, and it's taken out of context, as they say in Washington, D.C., that you can have some bleeding in the liver bed when you take the gallbladder out, because the gallbladder and the liver bed are connected with each other. What he went on to clarify, and he clarified it very well, was that you don't have bleeding like this lady had. When Dr. Lopez went in to do the remedial surgery, they took out 3,800 cc's as a minimum of blood and maybe some liver juices from this lady's abdomen. 3,800 cc's is a full gallon. She was bleeding when they took her out of the operation room. She had to be because of the fact that her blood pressure was falling in the recovery room. They gave her 2 blood transfusions before she was released from the surgical procedure in early February, even though the surgeon said that there were only a few ounces of blood that were lost. This is the case like Gilligan's Island. Lady goes in for something kind of simple that's supposed to take a very short period of time, but because of errors and errors and errors that were made, and there's another appeal before this court for 2 other doctors that we sued that hasn't come up yet.
What was the possibly or not fatal problem with your expert's affidavit and deposition testimony as to just proof of breach of standard of care, setting aside res ipsa right now? I understand that he testified that the trocars were inserted in such manner as to cause injury, but then said in his deposition he wasn't sure whether it was the trocars that did it. In your view, does it matter what instrument did it if the injury followed from the surgery?
That's exactly correct. It doesn't matter. What happened was that when Dr. Sangude was asked as to whether or not he knew how long the trocars were and other questions, he vacillated a bit by saying, well, if it wasn't a trocar, it was certainly something. The other thing that's a mystery to me and very disturbing is the possibility that the injury to the artery was caused by a disease that she had before the operation. That's a violation, in my opinion, of ER 3.3 because there's absolutely no evidence that she ever had the disease, and she certainly didn't have it before she came in, because there are two elements that they test for, and Dr. Para in his initial consultation report said that the lipase and the the other one is not important. Those two, they were normal, which means she did not have a disease that could have caused injury to the artery. The injury to the artery was caused by something that went into her body.
Are you talking about pancreatitis at that point in time?
Pancreatitis.
Okay.
Yes.
But didn't he also testify that there's a risk associated with this particular surgery, even if it was performed correctly?
Well, he did say that you can have some bleeding, but he went on to clarify that at least twice in his deposition by saying not like this, not 3,800 cc's of bleeding over a period of 5 days. That's a whole gallon of blood, about half of what she had.
What is the normal, what does the record tell us is the normal risk of bleeding from this procedure? Is it that an artery will be severed, or is it that something else will cause bleeding?
A small amount of oozing from the liver bed can happen, but in Dr. Sangove's experience with 1,700 of these, it never happened like this. It clears up. When she was taken to the recovery room, in less than an hour, her blood pressure was falling. It was falling because she was bleeding. They gave her 2 units of blood while she was there, even though she didn't lose any. They knew she was bleeding, but I suspect hoped that it would stop. It did not stop because of the fact that there was, according to Dr. Layton, who looked at the situation later, an accidental laceration of the liver during that operation. An accidental laceration is not the way these things are done.
Was the bleeding from a laceration of the liver or from the artery?
From the liver. The artery burst some 2 weeks later.
That's right. Okay.
But it healed itself somehow, and the lady's still alive. She is absolutely lucky that this is not a wrongful death case.
Okay.
Her sister was there as a nurse to save her life. I see that I only have 7 minutes left. If there are no other questions, I'll reserve the remainder of the time.
All right, you may do so. Thank you.
Oh, let me, on Dr. Lopez, I'm sorry. There's an argument that his information wasn't timely disclosed. That simply is not true. There was a stipulation of the parties that the discovery period would be extended until after, in March of that year, the motions were filed. And the other problem is that they named him, the defendants named him as a non-party defendant because they claimed he was the one that committed malpractice by fixing this lady, by going in and stopping that bleeding that had been going on for 5 days. Dr. Lopez's information was not only relevant, but it was timely, and it should have been considered. Thank you.
All right, thank you. Counsel.
May it excuse me. May it please the court, my name is John Egbert. I represent Dr. Para in this appeal. Let me just very quickly address the last issue that was raised concerning the untimely additional information that was attempted to be presented to the court and is relied on today and in the briefing in this appeal as the basis for overturning the summary judgment. It was late. The judge so found. The discovery cutoff is not the relevant cutoff. It was a disclosure failure, and the disclosure deadline was in February, and they did not rely on it until, actually it was in January, and they did not rely on it until February when they filed their motion for a new trial. So the court did not abuse its discretion in declining to consider both Dr. Lopez's not deposition, but his opinions, as well as there's some additional pages of their own experts' deposition that they tried to put into that motion for a new trial, pages 14 and 16, and those are the ones that counsel now relies on to say, well, he did say that the liver, there would be bleeding. He admitted that there could be bleeding even when the operation is done properly, is what we put into the record, and the court relied on in granting summary judgment. And then the late filed additional pages attached to the motion for new trial is where counsel argues from the saying that, well, he explained that away. That wasn't before the judge at the time and cannot be considered, I assert, in this court in terms of whether or not the court properly granted summary judgment. So I think if we leave all of those additional pieces out of the equation, then we're with a very simple analysis of whether or not the trial court properly granted summary judgment, notwithstanding the doctrine of res ipsa. It's important to also recognize that they did not challenge the grant of summary judgment based on lack of causation in this appeal. That's not one of the issues that they raised. They didn't say the judge got it wrong by saying there was an absence of expert opinion as to causation. They simply said the judge was wrong in not applying the res ipsa doctrine, and if, presumably, the argument would be if the judge had, then that would have been improper to grant summary judgment. There's a fatal defect in that argument before we even get to whether or not the essential elements of res ipsa are satisfied, and that is, as counsel even alluded to in his opening remarks, that the res ipsa doctrine is a tool by which the absence of direct evidence of negligence, i.e. falling below the standard of care, can still be satisfied even if you don't have direct evidence. And you can just rely on the circumstantial evidence of, number one, that it's the kind of injury that doesn't happen generally absent negligence, and number two, that the instrumentality was exclusively within the control of the defendant. Well, the case law is clear that, leaving all that aside, res ipsa doesn't solve the problem of an absence of causation. You still have to prove, even when you rely on res ipsa, that there was proximate cause. And we cite the case law in our answering brief that stands for that proposition, and it's unrebutted. So
what's missing here, in your view,
here,
on that point?
Well, here the judge found that there was an absence of expert causation testimony, both with respect to the artery and with respect to the liver. Those are the two areas of injury. With respect to the artery, their own expert testified that pancreatitis is another possible cause. And nobody's ever asserted that somehow Dr. Parra caused pancreatitis to be, a disease to be within her body. And he said that he could not eliminate that as the possible cause in this case.
But the law at this point doesn't require certain evidence. It requires evidence from which a jury could find the elements of the claim. And people get confused about res ipsa often. It is not a claim unto itself. It's basically a way of structuring an approach to circumstantial evidence. Right? So one of the elements of res ipsa, if we follow that approach to evidence, is causation. The second element requires that the accident be caused by an instrumentality within the defendant's control. So if res ipsa were met, it seems to me that you wouldn't need more evidence of causation. You would have a res ipsa case. But if you don't have a res ipsa case, don't you then go back to the normal rules of medical negligence?
Well,
I guess I'm asking you the same question I asked your colleague. I'm unclear why we're treating this as though res ipsa were some independent doctrine that must be satisfied or the claim goes away.
well, I think it's true in the procedural context of this case because the trial court judge, found that there was no causation expert testimony. And that was the basis for granting summary judgment, and they have not challenged that ruling on appeal. And so I think we start from the proposition that there is no causation. And res ipsa, even though there's some, the law, the elements may have some, causation aspects of it. I don't think it's intended to be, if you satisfy all those elements, that doesn't mean you have causation. You still need an expert witness to come in a medical context, that will come in and say, that falling below the standard of care was the cause of this injury.
But we have an expert that says that there is evidence of causation. That expert happens to have been very effectively cross-examined, meaning that the expert's testimony is anything but conclusive, but it's not non-existent.
Well, Your Honor, I disagree to the extent that there's no clear division between standard of care and causation. When a doctor is talking about what occurred here, there's some bleed over in one to the other. But what is missing? What is clearly missing from this case? Well, let's take the two different. Let's not blend them together. Let's talk about the artery first. Their expert said that one possible cause of these kinds of injuries is instrument that can impact on the artery. Another possible cause is pancreatitis. And then he testifies in his deposition that I cannot say that the pancreatitis did not cause the pseudoaneurysm. So if an expert can't say that it was either this or that to a reasonable degree of medical certainty, then I think that's kind of the standard that we use.
Well, don't we use a more probable than not standard?
But I think that's right. But I reviewed all of the pages that were attached to the summary judgment motion and response, and there's nothing that gets them there. There's nowhere does he say that more probably than not it was this instrumentality. He says, I can't tell you what it was.
But as you read that question to us, and I've not read that excerpt, as you read that question, the question seems to take as a given that there was pancreatitis, and what we read in the briefs and we hear now is the evidence was absolutely not.
And Your Honor, that's my next point, because the only evidence, you have no evidence that there wasn't pancreatitis. You have counsel's argument, and he's asserted it as such. There's no doctor in this case that ever said there was no pancreatitis.
But is there a doctor that says she did have pancreatitis?
There is record evidence. It's Exhibit P to Index of Record 86, where Dr. Singh examined Ms. Korak on February 21st, and he diagnosed that she had, quote, probable pancreatitis. And so what counsel does is he goes elsewhere in the record and he finds two readings on these tests that he says comes back normal. And then he says, again, attorney says that means that couldn't possibly be pancreatitis. And he even says that it's an ethical violation for me to assert otherwise. That is not the case. There is no doctor's testimony here that says that there was no pancreatitis. Their own expert said that he cannot eliminate that as a possible cause for the artery. Then if we get to the liver bleeding, their own expert once again testifies that there can be bleeding even in a properly performed procedure.
But there was a lot of bleeding.
There was a lot of bleeding, and there's no evidence in the record before the court when the summary judgment was decided that where his doctor, his expert, or any other doctor suggests that the amount of bleeding here could not have happened but for negligence. Nobody says that. There is no evidence in this record that supports the first element of res ipsa, which is that this is the kind of injury that doesn't happen unless there's negligence. That's something that is kind of just a pro forma expert affidavit language that always appears and is absent here. There is nothing in the record, including the deposition, where any doctor says this is the kind of injury that doesn't occur absent negligence. And their own expert says, well, you could have bleeding even when it's done properly, and one possible cause of the other injury, which was the artery, was that it could be instrumentation, it could be pancreatitis, and I as I sit here today, I don't know which of those, whether it's one or the other. I can't tell you. And it's something that very easily could, the deposition wasn't taken in front of the judge at the oral argument on summary judgment. We filed our motion. If Dr., I don't know how to pronounce his name, if their expert would have been able to testify otherwise, they could have provided a supplemental affidavit and said, no, they're wrong. There is no that type of bleeding on a liver. And no, I'm more probably than not, it was the trocar and not the pancreatitis. That didn't happen. There is no evidence here that supports, that would indicate that the judge was wrong in finding no causation expert opinion, but they haven't even appealed that. We shouldn't even be talking about it because you can't raise for the first time in a reply brief arguments that you didn't make in your opening brief. And it's not even listed as an issue on appeal here. But it also can't be used to support their res ipsa argument because there just is no evidence that these are the kinds of injuries that occur only in the when there's negligence. It just doesn't exist here. So we would ask that the court, first of all, ignore all of the stuff that was untimely presented. The trial court judge's ruling as to summary judgment should not be judged based on information that wasn't even presented to the judge at the time that the ruling was made. And we submit that the issue about whether or not there really is enough evidence of causation in the record, if we want to take another look at what the judge decided and second guess that shouldn't be addressed, we submit, because that's not an issue that they've raised, at least until their reply brief. And finally, as to the issues that they have raised with respect to res ipsa, there is no evidence that this is the kind of injury that can occur only when there's negligence. Indeed, their own expert testified to the contrary, and we would ask the court to affirm summary judgment.
The standard is, though, that the injury couldn't ordinarily occur, not that there's no way it could occur.
Sure. I agree with that, Your Honor. But even taking that, that language, there's nothing in the record that supports that. I would ask counsel to show us where there's evidence where Dr. What's that?
I plan to. Just that.
That there's anywhere where he can quote language by any doctor, let alone his own expert, that this is the kind of injury that doesn't occur ordinarily without negligence. It doesn't exist.
Well, ordinarily, you talked about the bleeding. this bleeding here was not the ordinary bleeding that we may expect in this kind of procedure, correct?
I can't say that, Your Honor.
Well, that's what I'm asking. Is there any evidence to support that going either way?
There's the only evidence that goes one way or the other goes my way, and it's where at first their expert says, can you have significant bleeding, is the question, from the liver or liver bed after a reasonably well-performed lap chole? Answer, probably not from the liver bed, but from the, well, I will retract that. Yes. The answer is yes. You could have bleeding. So in answer to a question about can there be significant bleeding, he first says no, and then he retracts it and says the answer is yes, you can. So that's the evidence that was in front of the judge.
And there was no follow-up on whether he was referring to significant bleeding or otherwise. It's just the answer stands?
There's no, in this section, in none of the pages that were presented to the trial court at the time of the summary judgment was argued, and at the time it was decided, there's nothing that contradicts that. If there are no other questions, we would, again, ask the court to affirm the trial court's grant of summary judgment.
All right, thank you. Counsel, any further word?
I realize that we're almost out of time. I would prefer to answer questions if there are any at this point.
Well, I guess the question is the one that I foreshadowed. Can you show us where in the record there is testimony that more probably than not this injury resulted from negligence?
Well, Dr. Lopez certainly says that. And I can't imagine how you could exclude Dr. Lopez's position because he was in fact disclosed in the initial disclosure statement. They filed a notice of non-party at fault and an expert opinion.
But this isn't really a discovery disclosure issue as much as a summary judgment issue, right? We have to look at what was before the trial court in a statement of disputed facts at the time the court decided the motion. Well, and so if we look at the record in that way, as the rule requires, what evidence do we have to say that more likely than not, more probably than not, this injury was the result of negligence?
When a surgeon says, I've had 1,700 of these, and I have colleagues who've had maybe several times that amount, and I've never heard of it, I've never seen of it, it doesn't happen in a surgical procedure if it's done correctly. And if it happened to me, he said, I would have to admit that I did something wrong. That is, in fact, what you're asking for. What bothers me most about what we were talking about here, and it really bothers me because of the fact that ethics are important. There was never any time when this lady had pancreatitis. What they're referring to is something that was done 20 days later when she was brought back for the second time to a hospital, almost dead, and the amylase, I think it was, the two amylase and lipase were the two things they test to see if pancreatitis is present. One of them was elevated, I think it was amylase. And he didn't say probable, he said possible.
We are not a court of ethics here, but you've made a serious charge, and so I need to ask, what fact is being misrepresented or concealed? It sounds as though we may have very different takes on the evidence. We may have a dispute of fact, but I don't detect that the wool is being pulled over my eyes.
Well, let me tell you how the wool's being pulled over your eyes, because it has been. Our expert did not know anything about the issue of pancreatitis because it wasn't in the records that he had. It was in the records that were 20 days later when she came back to the second hospital. There is a statement by Dr. Parra, the defendant appellee that we're talking about here, that amylase and lipase were normal. That statement was made because of the fact that they're concerned about the possibility of pancreatitis when they do these surgical procedures. It ruled it out. She did not have pancreatitis when she went in for the surgery.
And which doctor entered that opinion into the record?
Dr. Parra himself. It's in his consult note of February 1st, that amylase and lipase are normal. That's a statement she doesn't have pancreatitis. The statement that she may have had it was 20 days later when she had been beat up and been through surgical procedures. As far as what caused this, there are only two possibilities. One, that something very unusual happened that can happen without negligence, or two, Dr. Para, when he inserted some instrument, it was either the trocar that he shoved in where the instrument went, where the artery location was, or they put what they call a varus needle in there, and they inflate the abdomen with a gas so that they can see around and about and they don't hit things they shouldn't hit. Something hit her artery, and that artery ended up with the loss of her spleen. As far as the liver is concerned, Dr. Lopez and the doctors at the hospitals and their records that were disclosed immediately all say that during the surgical procedure there was an accidental laceration of the liver. That accidental laceration is not something that happens without negligence, and both Dr. Lopez and Dr. Sangode said that it just doesn't happen unless somebody makes a mistake. The mistakes were, one, he hit the artery with something that he stuck in this lady's abdomen and caused damage to the artery wall that ended up causing that artery to swell from something as small as a not much larger than a thread to something that was more than 2 inches in diameter before it burst. And as far as the liver damage is concerned, Dr. Sangode clearly said this doesn't happen unless somebody made a big boo-boo. And they did. She did not have pancreatitis. There's nowhere in any of the evidence that she ever had it. There was a possibility 20 days later that she may have developed it, but even then she didn't have it. Are there any other questions? I have 49 seconds.
No, thank you very much. The matter is deemed submitted. We'll issue a decision in due course.